We go on record?
Well, maybe that is. Let's go ahead and go on record. There's a motion made by Mr. Davis with regard to the Fifth Amendment argument that you made to quash a subpoena. And Mr. Whitley advised, I'll leave it to you. This could be a motion that we can have in chambers, or we could do it here in the courtroom. What's your preference?
Do it in courtroom.
Okay, all right.
One other option is we could do it when the time comes for it.
Yeah. Well, I think it's appropriate to go ahead and have it heard now. So let's go ahead and Mr. Davis, you want to go ahead and state your arguments in response to the motion to quash, or in favor of the motion to quash?
What I want to do is, Your Honor, I want to amend my oral motion to include some things that I wasn't prepared to present yesterday.
Okay, go ahead, Mr. Davis.
So, on behalf of April Taylor, I amend my motion to quash to include not only the Fifth Amendment to the U.S. Constitution, but Section 11 of the Kentucky Constitution, and consistent with my email last night.
Okay.
I also want to rely upon an additional case, McLemore versus Commonwealth. McLemore is reported at 590 Southwest 3rd, 229, Kentucky Supreme Court, 2019. It explains pretty much what the law is in the state of Kentucky as it relates to the issue that we're about to proceed upon. Now, it also reaffirmed that Clayton versus Commonwealth is still good law and it is the foundational law to be guided by this court. So in Clayton versus Commonwealth at 786 Southwest 2nd, 866, specifically page 868, Kentucky Supreme Court, 1990, and I quote, "Federal law establishes the principle that neither the prosecution nor the defense may call a witness knowingly that the witness will assert his Fifth Amendment privilege against self-incrimination." I'm going to omit the citation that they cited in there. Second thing is, in Kentucky, the law is prosecution may not call a witness knowing that the witness will invoke the Fifth Amendment immunity. And also, Clayton extended that to include the defense to make it parallel with the federal law. Now, I know I cited U.S. versus Ballard, Sixth Circuit case, but I'm sticking with the Kentucky authority primarily because of Section 11 of the Kentucky Constitution. The federal government has no right to construe or tell the Kentucky courts how to rule on Kentucky law or Kentucky Constitution unless it violates federal law. Now, Section 11 is a corresponding section to Fifth Amendment of the U.S. Constitution. It's almost virtually identical. It's similar to the Section 10 of the Kentucky Constitution, which applies the Fourth Amendment prohibition that is contained in the U.S. Constitution. So you got those two parallel tracks. Kentucky Constitution deal with Fourth Amendment violations, Section 10, Fifth Amendment violations, Section 11. Now, McLemore is very instructive because it gives an overview by the Kentucky Supreme Court of what the law is from Clayton. It brings it all the way up and discusses all the cases in between Clayton, Brown, Combs, and all those cases that Kentucky courts have dealt with, and then it neatly packages it between pages 236 and 241 on what the law is and how to deal with this issue. First thing, the court reaffirmed Clayton, so it's still good law, but the court give this court two instructions. One is that you do a dry run out of the president of the jury, which is what we're going to do here today. Second thing the court says, that the lawyer can invoke these privileges and not the client has to be the one. Third thing is that the courts grapple with, in some of the cases they reviewed, the client or the witness was asked their name and address, and then the lawyer invoked the privilege. And in some of the cases, the lawyer invoked the privilege even on the name and address. Either way, the Kentucky Supreme Court in McLemore approved that procedure. So it is my intention to do the latter. To invoke Fifth Amendment to the U.S. Constitution in Section 11, even if her name is being asked. I'm not going to testify to anything, name, address, nothing, based on Kentucky Supreme Court decision 2019.
Okay.
So that's what our position is. Thank you for allowing me to modify my oral motion, and that's where we're ready to start, Your Honor.
Thank you, Mr. Davis. Mr. Roberts, you want to address his arguments?
Well, just briefly, I think the law says that a witness to be excluded must have a reasonable fear of danger of prosecution. Now, this witness, if she becomes a witness, and I don't know if she'll become a witness or not, I've got her here for rebuttal, in anticipation of what Sarah might say in this case. I don't know if I'm going to call her or not, but if I sit her in the courtroom and Sarah testifies and I want to refute that through her sister, then I think I should be able to do that. Now, can she claim the right of Fifth Amendment privilege? She's answering the question, she can. I mean, she's going to take over this trial, I got a feeling. I don't think she can do that unless they can explain, if Taylor can explain what fear she has for prosecution of whatever she's saying. And that's the law.
So, Mr. Davis, you want to just respond? And
Yes, I did. I anticipated him bringing that up.
Sure, and Macklemore even says, I think, that
Reasonable
we have
possibility.
to bypass this ability to hide behind, quote, an imaginary or unappreciable danger of risk that should be prosecuted.
Yes, Your Honor. Macklemore is the guiding principle. If we're going to, I'll stick my flag in Macklemore. Based on Macklemore and anticipating what Mr. Roberts is going to say, and based on my years as Assistant Attorney General doing criminal cases on behalf of the Commonwealth and Assistant Deputy Attorney General for the Commonwealth of Kentucky, I looked at the law, and these are two things that I came up with last night. One is that federal law, that they cannot immune her from federal prosecution. We know that from the George Floyd case. State conviction being a federal conviction. There is no double jeopardy when you deal with the federal government versus state government. Federal law, 18 U.S.C. section 231, A subsection 3, clearly states civil disorder. Whoever commits or attempt to commit any act to obstruct, impede, or interfere with any law enforcement or fireman that is doing their official duty and engage in the lawful performance of that official duty can be charged with civil disorder under federal law. And we know, Judge, from all the stuff he presented already, from all the stuff he's been throwing April name in, we're talking about at least civil disorder that could go and support a federal indictment. You can't hide from that because they don't put too much of her name in all of this stuff. Second thing is, again, anticipating him coming up with this, 18 U.S.C. section 373 subsection A, solicitation to commit a crime of violence. He said, she got her Facebook stuff and she's talking about doing all this stuff. Oh, we're going to be violent, we're going to shut this stuff down, we're going to do all this against the police. Basically wrapping it all up into a violent, getting the mom to do some type of violence that April was trying to do. Okay, well, the federal statute covers that as well. So it's not imaginary, in my point of view. It's not imaginary when you got everything thrown against the wall on April Taylor that's been heard in here today. There's no way it could be imaginary. And then Luke Macklemore said, reasonable possibility, not probability, not reasonable certainty, but possibility. I submit to this court that it is reasonable that what he has done here today will subject my client to federal prosecution. Now, whether or not the federal people pick it up, that's not my burden to show. My burden to show a real threat to my client. I think I've done that with these two statutes. Thank you, Your Honor. God bless you.
No, sir. No, sir.
Based on the case law of Clayton versus Commonwealth, where it clearly says the prosecution may not call a witness knowing the witness will invoke the Fifth Amendment immunity, and based upon Macklemore, which allows the attorney to assert that privilege, basically, I consider it a dry run that Mr. Davis has indicated that he is not going to allow his client to answer any questions without invoking the Fifth Amendment.
And Section 11.
And Section 11 of the Constitution. I think he's articulated sufficient cause under federal law that there are dual sovereigns and that Ms. Taylor could potentially be subject to federal liability or federal criminal liability or charges. Also, I'll note that you did make this argument, but that there is no statute of limitations on felony charges in the Commonwealth of Kentucky, such that if there were any proceedings with regard to allegations of her being involved in a felony, that the Commonwealth could bring those charges as well. So based upon that, I'm going to sustain the motion to quash. My question, Mr. Whitley, is based upon.
May I have the excuse?
You may, but before you, I do want you to come up to the bench in a second. I want to talk to you real quick. But Mr. Whitley, before I leave this issue, I just want to know, what your proceedings or what's your idea on informing you don't want to inform the jury of my decision termination?
No, based on the court's ruling, of course, I have to make a different kind of motion. I think they can anticipate that. This court allowed testimony and statements made by April Taylor against my client. And
Because
now-
they were intricately intertwined with the case that the prosecution is.
But the court's aware that I no longer have a right to confront and cross-examine witnesses, and that introduced potentially with April Taylor being subjected to being testified. Now she's not going to testify. I believe that we have to move for mistrial if I don't have an opportunity to confront that information, put it in the proper context of the Constitution. So that's where we are today. That's
Yeah.
why I made a strong objection on pre-admitting it. That's why I made a strong position that she may plead the fifth. That's why we stopped the proceedings yesterday.
Well, I'm going to overrule the motion on this trial. But at this point, with regard to my ruling, you want to keep the jury from knowledge of this ruling, is that my understanding?
No.
No, you want to be informed of the ruling as to the
Yes.
motion to quash? Okay, all right. Mr. Roberts, any response as to just informing them as to why Ms. Taylor, because, it impressed upon me, Ms. Taylor, there was a scene yesterday. Ms. Taylor left based upon the subpoena being delivered to her. And so do you think it's fair to tell the jury as to why she's sitting in the courtroom and why we made the, determination that she could sit? Because I think she could sit in the courtroom.
I'm going to ask her to leave, Judge.
Are you going to ask her to leave?
Yeah, I don't want to complicate this trial. I don't want to be dragged in any more than we already have to. I don't want to go through any more additional research. My hourly rate is $5.50 an hour.
So, Ms. Taylor,
I'm not paying
I just-
you. I need to leave.
So then it's not an issue.
Your attorney's going to ask you to leave, so
I
I
can't
just
make
want to
her-
make sure, I know you can't make her leave. I don't know if anybody can make Ms. Taylor do anything. So, Ms. Taylor, I'm just based upon my ruling, though, in the advice of your counsel, and I appreciate you're probably here, you want to support your sister, but are you willing to listen to his advice and leave the courtroom? Otherwise, I think that we need to have a conversation.
I will, then I'll modify that myself. My client has a right to a fair trial. I can care less about the actual.
Understand.
I know that depending on how things are done, I'm here because my client wants it, she's not guilty. So I don't want anything to potentially prejudice my client in any kind of way.
Mhm.
So regardless of people's position, their constitutional right to an open courtroom, we didn't spend this much time and this much energy fighting this case and coming today to give a potential mistrial before anything's done. So I'm going to order this over here.
Okay.
Okay.
Well, based upon, this is Ms. Williams' case, consultation with her attorney at the advice of your counsel, Ms. Taylor, he's asking you to leave. Ms. Williams is entitled to a fair trial.
I was fine in the courtroom until y'all started moving crazy, screwed up moves, violating my constitutional rights.
Well, at this point in time, I'm preserving your constitutional rights by ruling in the favor of your motion for Mr. Davis. But upon Mr. Whitley's request, upon Mr. Davis's advice, I'm going to ask you to leave the courtroom, okay? Thank you, ma'am.
So what you telling me I can't come
I'm
back?
ordered you to leave the courtroom. Yes, ma'am.
I understand, I explained to my client that typically when procedures are happening, the street, you have a right, the First Amendment right inside the courtroom.
I can't hear you, Dan. I can't hear you.
You have a thing called contempt powers. So I do appreciate the court not
Yeah,
doing what you would typically do if you were personally acting on your court. So I think it'll last my client.
yeah, well, I mean, I'd probably be angry too if I was asked to leave the courtroom in order to, so I appreciate Ms. Taylor is very, very angry, and, we all get angry, so I'm not gonna hold her in contempt for
You
being
don't, I
angry.
mean, I remain in the courtroom, I promise not to cause any theatrics. I had myself.
Well, you already caused a lot of theatrics, I don't know, so,
Mr. Robert doesn't mind about that. He used to be my professor when I was in law school.
I
yeah.
don't mind a bit.
Old
He also
old
trained me.
buddy.
Also trained me,
As
too.
long as you're not charging me $500.
Okey dokey, so with that bit of an introduction, let's go ahead and call the jury in.
So, under the elderly black lady, she's not here yet. But I'm not guessing I can get Carrie and see if she can get a hold of her. But
Yeah.
keep them out there until then, you want to bring them in?
Let's keep them out there until we can get
Figure out where she is.
Yeah,
Okay.
yeah, please.
Do you know?
Yes, it's, her name was, Naomi Ferris. See if you can get hold of her. F-A-R-R-I-S, Naomi.